welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, who I'm going to call Bill. And Bill has his law office in San Jose, California. He's of counsel to Gates, Eisenhart, Dawson. He's been practicing law 33 years now?
Pretty close.
Oh
Pretty
my
close.
gosh. He has a master's in taxation, master's in letters of law from Golden Gate University, and a JD law degree from Santa Clara University. His practice focuses on estate planning and probate and business planning. Bill, thanks for joining me here today.
My pleasure.
That's great. So today, Bill and I are going to be talking about why you need a will. And before we get started, I just want to caution our viewers, as I usually do, that we want you to get legal advice. That's not what we're doing here. We're just giving an introduction to this subject. And also, Bill is a California attorney. I am a California CPA. And the flavor of this stuff changes from state to state, and also can even change from community to community in California. So, so just be aware of that. But again, we're going to be talking in a pretty general way. Also, today is September 3rd, 2013, to give you an idea of when we're recording this thing. All right, let's get started, Bill. Any guess about what percentage of our adult population in the United States doesn't have a will?
Most people do not have, most adults do not have any kind of estate planning, will, trusts, or whatever. I think the number is about a third of the people who would benefit from having a will do have a will, and the rest should but don't.
Okay. So why don't you think people don't have one?
Well, there's lots of reasons. You know, everybody's life is busy. There's procrastination. People don't wake up in the morning thinking, oh, I'm going to do my will today. Mm-hmm. So, you know, there's those kinds of, you know, conflicting things in their life that just they don't think about it as much as they probably should. And then I think there's other reasons people put it off because they don't want to think about dying. They don't want to think about who's going to get their property. Maybe there's some kind of confusion. Maybe it's going to raise some kind of issues in the family. You know, it depends on the family situation, but sometimes these things are better just left unsaid, you know. So in reality, they're never better left unsaid, but, you know, it's still not necessarily the thing that you want to deal with first thing in the day. So
They have a second marriage and their spouse, they're afraid their spouse is going to threaten divorce if they...
Well, it can bring up some very interesting topics of conversation.
Oh, yeah. Well, what are some of the things that eventually motivates people to go ahead?
Well, it's usually big events in people's lives. Things happen, and you realize, you know, we all are mortal. We're all going to die. So the day will come when something has to be done. And so it's something like a child is born. That's a big thing that gets people motivated. Or someone in the family dies, a friend dies. Sometimes people, because they get married, they start thinking about estate planning. So that's often what it is, just something that motivates you to start thinking about your future and what happens to the people you care about.
Right. You know, related to this, I think the more people that you have in your life, like, you know, your family and so forth, even in many ways, the more critical it is that you do something about this stuff. And like I said, like when you, or like you said, when you have an event like a second marriage or what have you, now, again, you may have these other players there, and so, you know, it gives you an opportunity sort of to be the referee during your lifetime.
Right, right. The issues become more complicated. Unfortunately, the other thing that motivates people sometimes is if they're in the hospital.
Oh, yeah.
And sometimes it's, you know, very, very much near the point of being too late. But occasionally I get called to the emergency room and, you know, long-term care facilities and places like that because people waited until the last minute.
Right. Yeah, I just saw a show last night. It's an old television show. But anyway, the childbirth situation. And so the woman, you know, was having difficulties in childbirth, and so basically brother sat down, okay, let's write your will.
Yeah, well, that's probably not the way you want to do it.
Okay.
Unless your brother's a lawyer.
Yeah. Well, in this case, yeah, at least it was a learned person. This was a long time ago. All right. Well, anyway, what happens if you don't have a will?
Well, it depends on the assets you own. First of all, you need to have an estate of some sort, before it matters, I guess. But sometimes people own their assets in such a way that it will transfer after they die. We'll talk about that a little bit more. But you can have things owned jointly, and it'll pass to somebody. If you don't have it set up that way, then there's the California Probate Code that controls what happens to an estate. So I tell clients who come to see me, if they haven't got any sort of an estate plan in place, that they probably have one, they just don't know what it is. It's the California Probate Code.
Right. So the laws of intestacy.
Right.
Okay. So if you don't have a will, how is an executor determined?
Well, without a will, it's not actually called an executor. If an estate goes through probate and there's no will, then you are said to be intestate. And the person who would be appointed to administer your estate would be called your administrator. It's the same job as an executor, but because they weren't appointed through a will, they're called an administrator. And the person who might do that would be someone who has an interest in the estate, probably a family member, but they have to petition the court to be appointed, so it doesn't happen automatically. And then if there's any argument about who should be doing it, that comes up at the first hearing, and other people might suggest that they be the administrator instead. But that's the process.
Okay. What are some considerations for small children, sort of, like the with and without a will type of a situation? What are some things to think about?
Well, as I said at the beginning, one of the main things that motivates people is when they start having children, and there's good reasons for that. Because if you think about it, first of all, your children really aren't able to take care of themselves. And because of that, the law doesn't really even allow them to inherit your property. And we're talking not about small children necessarily, we're talking about any minor. So anyone under the age of 18 is not really able to receive your assets directly. So if you die and you haven't set anything up, then a court-appointed guardian is going to have to take over most of the time to administer the estate of the minor children so that the property can be held for their benefit. So estate planning, a large part of that is stepping in and starting to make decisions, such as who would you want to be the guardian of your children if something happens to both the parents. So the parents have some say in who that is, and it doesn't have to be family members. You can start to select people and put them at the top of the list. And then also you can set up ways of managing the estate for the minors so that it's not necessarily done through a guardianship. It can be done through what's called a testamentary trust if you have a will, where you name a trustee and in your will, and the trustee manages the property until the children are older. And in this case, with a trust, it doesn't have to be age 18. It can be much later than that if you want to delay it.
So you have more control over the property management after your death if you have a document like a will or a trust.
Right. Well, yeah, what you're able to do is start to really control who takes care of your children, who manages assets for your children, and be in charge of that decision-making process instead of just having it turn out however it turns out after you're gone.
And you may have a situation that, again, you may have separate people, different people. So this person would be really good raising kids. This one's better at managing assets.
Right. I tell them, and this is one of the harder decisions couples make, is who's going to actually manage things for their children and who's going to have custody of their children.
Right.
But it's two different jobs, and you can have different people doing it. Sometimes it's a good idea to have different people doing it because the people looking out for the children are not the ones that are looking after the money. So you have different people kind of watching each other and keeping track of things.
Another thing that people need to think about, and in a sense that we're covering this, of course, there's a lot of single-parent households these days, so what happens, when that single parent's gone, but also you could have an accident where both parents become deceased. Maybe they're both, flying on a trip together, or who knows.
Well, the single-parent household brings up an interesting problem, which is that oftentimes the single parent, and most often the single mother, is raising the child or children. And if something happens to her, the person who actually has the first right to take control of the children is the natural father. And so if that relationship hasn't been broken through some adoption or abandonment or something legal, that's still the person who's going to have control over your children. And if that's not the right person to have control over their finances, then you definitely should be thinking about doing something. You can't necessarily prevent the natural parent from having their parental rights with the children, but you can have somebody else making the financial decisions by not leaving the estate in such a way that the guardian is in charge of the estate.
Okay. So let's move along here. What can you do with a will aside from naming an executor and a guardian for children?
Well, wills have other features. One of the main features of a will, disposing of your property, obviously. Well, you have all kinds of property. Personal property is another category of property. So, who gets your car, who gets the stuff in your home. If you have, family heirlooms or jewelry or things like that, you can control that. You can talk about about who, if you have special instructions for burial or cremation, you can talk about that in a will. Although you should definitely make sure other people know what your wishes are, so that it's not just in the will, because the will may not be read until after it's too late to change the outcome. So things like that. You also have the opportunity in a will to essentially you say what happens to your estate. You can also say who doesn't get anything from your estate. So you can disinherit people. It needs to be done carefully and correctly in order for it to work. But you have the right to leave property pretty much to whoever you want to leave it to. And so the ability to control who gets how much of your estate or whether they get anything at all is something you can say in a will.
Right. And you can actually create a trust inside of your will, right?
Yeah, that's what I was speaking about a little bit before with minor children, for example, is that because you can create a trust with the will, what happens is the terms of the trust are written into the will, and then at the close of the probate of the estate assets are transferred to the trustee of the trust, and then the trust goes on and is administered typically for the children of the decedent until it pays for education, it pays for care and things like that, and then when they're old enough, they inherit the property.
Right. So the alternative, of course, is to have a living trust, which is, most people these days seem to be doing if they have a formal estate plan.
Right.
And the main advantage I can see with the that type of a trust is basically avoiding probate. It's an advantage and a disadvantage. You can avoid probate, speed things up, and have some privacy.
Right.
So
yeah, the majority of the estate planning I do is living trust planning, and that's the primary motivation for that. Sometimes it's tax planning as well, but most of the time the primary motivation is to make it much smoother and easier at a person's death to transfer property privately without probate, without the expense and delay of probate.
Okay. So we talked a little bit about previous marriage. You may have any more thoughts about adult children or children from a previous marriage?
Well, again, these different situations create different kinds of issues to deal with. Problems is maybe too strong a word, but it definitely creates issues. So, for example, if you die and you have a surviving spouse and you have a home with that surviving spouse, it's a little hard sometimes to give things to your children at that point, children from a prior marriage, and they're not necessarily going to inherit from your surviving spouse. So you need to consider setting things up so that you can provide some benefit to your children and your spouse. So one way to do that would maybe to get some additional life insurance if you can qualify for that, and benefit your children or your spouse or both with some life insurance in addition to whatever they might inherit from you. And then again, with trust planning, you can leave things for the benefit of a surviving spouse, but at the second death, have it pass on, your share of it pass on to your children. So that's something you can do through trust planning, whether it's a testamentary trust or a living trust.
So I think that works pretty well if you've had just like one spouse and children from that marriage. And the problem is that if the person's got children from a previous marriage, then what's happening is that the new spouse, if you will, whatever, the current spouse, surviving spouse, is sort of like standing in the way of their inheritance, of their getting this house.
Yeah.
And
It actually works both ways, unfortunately, because the surviving spouse needs to have enough to live on and a place to live.
Right.
At the same time, the parent who died, their children, they're not really receiving the parent's estate. So it definitely creates tensions, and if you can find a way to use some assets or something like insurance to try to offset some of that, it helps.
Yeah. It's a real help. Life insurance can be a real help in the situation, and a lot of people, they fight getting it, but there can be reasons for having it.
Right. And I tell people that I've never heard anyone say after someone dies, "I'm sorry we had so much life insurance."
Yeah, yeah.
While they're living, it's a different story because you have to pay the premiums.
Right. Another thing related to this is a lifetime communication can be something that can help a lot. Family meetings and things, sort of discussing wishes. Some people feel different ways about that. Maybe it depends a little bit on the family. So,
well, you have to strike a balance because as an attorney, you can't really have an estate plan by committee.
Right.
So it's not like you sit around the table and people vote on how this should work. The client needs to make the decision, but it can be certainly useful for people to know what's going to happen and to have maybe some, and everybody will have some input, and getting everybody's ideas on the table doesn't hurt.
Maybe it can at least diffuse a shock that would be there otherwise.
Right.
What do you mean I disinherited?
and it may lead to a different decision that actually works out better for everyone.
Yeah. Do you have any more thoughts related to a second marriage?
Well, one of the things you think about when there's property from a prior marriage, maybe children from a prior marriage, is whether or not there should be a prenuptial agreement or premarital agreement before you get married. I also find that people don't do this usually after or before a first marriage, sometimes, but not very often. But after a second or before a second or maybe a third marriage, it's much more common because you've already been through all of the issues that come up and the battles. And so that's another kind of planning that can be done. You can set up an agreement that describes the status of the property, and in the event of your death or another dissolution of marriage, the status is established. And as long as you follow the terms of the agreement after you set it up, then it can be helpful in controlling all of that.
Yeah. It may be helpful, I guess, especially in these second marriage situations, to actually have an attorney for each one of the spouses.
Well, you pretty much have to. California has a very strict law that relates to premarital agreements, and there are waiting periods. And if you don't have two attorneys, one for each of the prospective people that are going to get married, I say that because the agreement only becomes effective if they do get married. But if they don't each have their own attorney, it's much harder to make it enforceable under the law. It's not impossible, but it's harder, so it's advisable for each to have their own attorney.
It might even be good for their estate planning too, though, right? I mean, other than the premarital, maybe even when they're putting together their will or trust.
Well, in the context of wills and trusts, even married couples have a right to do their own estate plan if they want. You aren't required to do it as a couple. And there even can be conflicts of interest for an attorney if you're trying to do an estate plan for a husband and wife together and they don't agree on what they want. So there are these limitations on what you can do for any two people, whether they're married or partners or whatever. So if that comes up, if there's a conflict of interest, then you can have other attorneys involved even in that process, or you can each do your own separate estate planning.
Okay. This may be a little different question than it was not so long ago, but how can you be hurt tax-wise if you don't have a will or a trust?
I think unless the estate is very large, these days the estate tax credits are quite large. They're over $5 million per person. And so for estate tax purposes, if it's a large estate, there can still be significant estate tax consequences if you don't have good planning. I really don't think that many states of that size have no planning at all. It'd be pretty rare. It's possible, but probably not a large percentage of the people with the large estates are going
I
to.
guess we had some celebrity who died here pretty recent. Wasn't the guy from The Sopranos or whatever? He didn't have a will. Oh my gosh.
It does happen.
Yeah.
But I really think the tax consequences for most people now are going to be more income tax consequences and maybe even real property tax consequences if things aren't handled correctly.
Yeah.
And so there are things that have to do with the fact that when a person dies, the basis of their
Right.
assets, capital assets, gets increased, adjusted up or down. And those things, if they're not handled correctly, can turn out badly. So there are right ways to do it and wrong ways to do it. And if you have estate planning, you're probably dealing with people who are going to help you do it, hopefully the right way, as opposed to a lot of things just don't happen because people who haven't got planning, when a person dies, they don't really do anything. They just kind of let time pass. And then the decisions that should have been made didn't get made, and years later it's much harder to go back and fix that.
Right. Where should you keep your will?
Well, there are different people with different opinions about that as well. Some attorneys keep them in a vault. I never have done that, and I don't believe in that because my clients move around. I don't know where I'm going to be in 10 or 15 or 20 years. I don't know where they're necessarily going to be, so I don't believe that's a good idea. I tell my clients to keep it in a safe deposit box, and of course then people who need to find the will, if something happens, need to know where that box, that it exists, where it is, and have some way to get access to it.
Yeah. I had a client that passed away a couple of years ago, and I had a copy of some of their documents, and I gave them copies, but they didn't know where the originals were. And the attorney had either moved or died, and so anyway, it was creating some havoc.
Unfortunately, that happens quite a lot, and even to my surprise, I find people who don't know where the original documents are, even though they have copies.
Okay. Have about 5 minutes left. Are there some recent developments maybe we can talk about for which wills and trusts should be updated? So even you folks, maybe you might even have a will, but it's time to think about this again, I think. Why don't you talk about that a little bit, Bill?
Yeah, well, we mentioned earlier the estate tax exemption. It's now quite high, and it is now permanent. By that, I mean Congress made the law permanent, whatever, and that means it's permanent until they change it.
So they change it, yes.
But it's not automatically going to sunset like it did before.
Right.
So there are still tax considerations involved in getting that right, and there are elections that can be made after a person dies that will affect not only the estate tax, but again the basis of the property and capital gains tax and things like that. So that's a good change because now everybody realizes that that's quite a large credit, and for a husband and wife, that's over $10 million. But there's still things to consider and planning to do, even with a large tax credit. But at least we know what it is.
Right, and it can modify a little bit of some of the things that we would automatically do before setting up maybe bypass trusts and other things that may not really be so necessary.
The other major change recently is the Defense of Marriage Act was overturned, and now different states allow same-sex couples to marry. And in California, that brings into play things like community property law and all the issues of community property. But also, on the federal level, that means that people now qualify as a spouse if they're legally married. And so all of the federal laws apply to them now as husband and wife, I believe, including the tax laws. So things like the unlimited marital deduction apply to people that are legally married.
So now, I mean, there are a lot of artful things that were being done in wills and trusts for these people, sort of contingency plans and other things. They can probably simplify their documents considerably if they do decide to do an update.
And also if they decide to get married, that's the other thing.
Yeah, that's another thing. So, and there is another thing that we sort of bypassed. It sort of is related to this large exemption, and that is this business of portability. And this was another thing that it had a sunset on it before. It was only there, it seemed like, for a couple of years. So that, okay, well, what's all this fuss about? And then they actually made it more permanent. Maybe you could comment about it for just a moment.
Yeah, well, first, what portability is, it's the ability, there are these credits. They're over $5 million. And a husband and a wife each are entitled to a credit. The question is, they're probably going to die at different times. The question is the first spouse's credit taken at the first death and the second taken at the second death, Or does the surviving spouse elect to move both credits to the second death? That's possible. That's what portability is. You have to do something affirmative at the first death in order to create that possibility. As far as I know, it's still filing the 706
Yeah,
tax
you
return.
still have to file the estate
the only
tax
way you
return.
can do it.
Yes.
But that's a decision that you would want to make. And I have clients who are deciding yes to file or not to file for that very reason, because their estate isn't large enough for the tax
Right.
problem, but if they want portability, they have to do that.
Right. And if they can win the lottery, then they'll wish that they did if they didn't. Okay, so anyway. Okay, well, I have maybe about a minute left. Bill, maybe you can throw out a thought as we conclude this idea of why you need a will.
Well, I really believe, as you said at the beginning, that an important part of all this is you don't have to see me, but if you're going to do planning of any kind, well, if you're not going to do any planning, then you're going to be living with the consequences of the probate.
Or your family will be.
Yeah, but if you're going to do it, you should not try to do it yourself. It's complicated. There's lots of issues. You can get forms for this, but you really shouldn't try it. And you should see an attorney and get some good, sound advice from somebody who's done estate planning.
So this is one case where it doesn't pay to be cheap.
Well,
and there are kits around. I mean, there's software,
Right.
to it. And
It can be
companies
very
sell.
expensive to be cheap.
It can be very expensive for your family in the long run. And especially, again, folks, if you got a second marriage situation or something like that, or children from previous marriage, you really do need to give attention to this. Well, folks, we're all out of time. Thank you very much for joining us today, and I hope that we've given you some things to think of. And we'll see you next time on Financial Insider Weekly.